I have in my hand some papers of the Karnataka University of the Civil Procedure Code and Limitation Act. Let us discuss some questions and answers, how to answer the questions in the paper. Many of the students know the answers. We have read the substantive provisions, we have read the Civil Procedure Code, but to write the answers in the examination within that allotted time is to be seen how it can be done more effectively. First of all, let us discuss one paper. There are three kinds of questions in this paper. First, we have long questions which ask for an answer which may have about 16 marks allotted to it. Secondly, we have short answers, that is short notes, which may be 8 marks each. Then we have some illustrations. One last question will be on illustrations, in which the example is given and then we have to write the answer, how to tackle that particular problem or how to advise that particular person, what they have said in the illustration. Let us see everything one by one. First of all, for the long answers. Now we have studied the provisions. We don't know how many pages we have to write, how much answers we have to write, what is the important thing, and maybe that when we are writing the answer, the time flies. So first of all, while answering the paper, we need to see that we allot the time for each question accordingly, and we should balance the time. We should always keep a track of the time that we are going to answer all the questions. Please do not leave any questions, because if you answer one question containing 10 to 15 pages, you may get the full answer for that question, but you may get the full marks for that question, but you may not be able to secure the marks for the paper or for the exam. So first of all, how to allot the time is one thing which the student has to master. Secondly, when he starts with the paper, when he starts answering, he answers those questions which are known to him better, that is, in which he is sure of answering it. So when you are writing the answers, first of all, let us say it is a long answer. First question: explain the provisions of the Civil Procedure Code 1908 in respect of transfer of suits. This is for 16 marks. Now, how do you answer this question? First of all, we have to mention the provisions of the Civil Procedure Code. That is very important. When we are giving a writing or we are giving an answer, when we are writing an answer, we need to first see that we look into the legal provisions first and then we explain. So first of all, mention the article or the section which you have studied relating to that particular provision, and then you go to explain that. And finally, you give a illustration for that, and then at the end of the answer, finally you have to give the conclusion. So first of all, when we say what are the provisions in respect of transfer of suits. Now a plaintiff, we know he is called as dominus litis. That means he is the person who decides which case has to come before which court, or he has to choose the forum where he has to file the suit. No court will force the plaintiff to file it in a particular court only, but there is a jurisdiction of the court, and according to the jurisdiction of the court, according to the provisions of the CPC only, he has to file the case. Now here you have to say that, first of all, section 22 and 23 of the Civil Procedure Code, these are the legal provisions. They are applicable to such situations where they empower the courts to transfer the suits. That means in some conditions, though the plaintiff is having the power to file the case in any court, even then some courts may not have jurisdiction, or in some circumstances the cases may have to be transferred from one court to another. So the court has a power under 22 and 23 sections of the Civil Procedure Code to transfer the cases. This is an extraordinary power, and therefore the court has to exercise it carefully. This has to be mentioned first. So you mention section 22 and 23. First you mention that plaintiff is dominus litis, so he has a power to, or he has a right to file the suit in any case, in any court. Secondly, you have to mention the power of the courts under section 22 and 23. Then give an example. See, for example, a husband and wife. The wife does not have her own income. They reside separately. They are in two different cities. And the husband institutes a suit against the wife in a place where he is residing. Now the wife will find it very difficult to contest the suit. Therefore, she may apply for transfer of the suit to the court in the city where she is residing. Now, if the husband agrees to bear the court expenses of his wife, the transfer will not be ordered. That means there are conditions when the transfer will be ordered. It is difficult for her to go before the court and to bear the expenses of the court. But if he says that let her come here and let her contest here itself and I am ready to pay the expenses. In such cases, it is not necessary to transfer the suit. So when the transfer can be effected? When it is necessary that the person has to transfer the suit to some other court, whereas if he transfers the suit in another court, then only he will be able to contest that suit properly. So section 22 allows the defendant to make an application for transfer of the suit from the court in which it is pending to some other court. So what is section 22? It says that the person can make an application before the court and he can apply for the transfer of the case. Section 23 states the court to which the application may be made. So in which court the application can be made. So what are the requirements? Then you have to mention the requirements. First you say what is the plaintiff's rights, then you give an example, and then you say that what are the requirements of section 22. Here the requirement is that first of all there must be more than one court which is having jurisdiction to try the suit. Secondly, the suit must be pending in one of the courts. That means transfer of the suit from one court having jurisdiction to another court which is having jurisdiction. So you can mention a case. Krishnaji Rao versus Gokul Das. In this case, the defendant questioned the jurisdiction of the court, and then after questioning the jurisdiction of the court, he applies for transfer of the suit. This cannot be allowed because when he is making contradictory pleas, for example, first he questions the jurisdiction of the court. When he questions the jurisdiction, then he files an application on that matter questioning the jurisdiction. So then he cannot make suppose he makes a application for transfer to that particular court where the other party says that it has jurisdiction. It means that he is admitting that. So when he is filing an application questioning it, he cannot file for transfer again on the same grounds. So here it was held in this case that a defendant who questions the jurisdiction of the court in a case cannot apply for the transfer of the suit. So that means the suit should be pending and what the plaintiff or defendant has a right. Thirdly, the defendant must make an application to the competent court for transfer of the suit. So whichever court is competent to try that suit, the application must be made at the earliest opportunity before that court so that the transfer can be effected. And mainly, that application should be before settlement of issues. Now, before presenting the application, the defendant must issue notice of the application to the other party so that they will be able to know or they will be able to contest and file an objection. After hearing both the parties, the court will pass an order and allow the transfer. Now, section 23 speaks about the application of transfer to the court. Which court can allow this? See, where there are several courts having jurisdiction, then all the courts are subordinate to the same appellate court. Then an application under section 22 shall be made to the appellate court. There are different courts. For example, in Karnataka, we have several courts. One court at Mandya, one court at Mysore, one court at Bangalore. They are all subject to the same appellate court, that is the High Court of Bangalore. Then in that case, the application has to be made in the Bangalore High Court. Then when the courts are subordinate to different high courts, for example, one court is in one state, that is in Karnataka, and another court is in the state of Maharashtra. Then the application will be made to the High Court within the local limits of whose jurisdiction the court in which the suit is brought is situated. That means where the suit was brought in the first instance. Suppose it was brought in Mysore, then the High Court here is the High Court of Bangalore. So then the application will be made to the Bangalore High Court, because under the Bangalore High Court we have the Mysore court in which the case has been filed. So the High Court has a power to transfer a case from a court which is subordinate to it to another court which may or may not be subordinate to it. So this is how the answer has to be given. So first you have to mention the right of the plaintiff, then you have to mention the power of the court, then you have to mention a example. You can give any example talking about the transfer of the cases. Then you can give an example speaking about the transfer of the cases and which court has powers. Then you have to mention section 22 and section 23. 22 speaks about the conditions of transfer. 23 speaks about which court you can file for transfer of the case. So this will be a complete answer to the question, that is, explain the provisions of the Civil Procedure Code in respect of transfer of case. This is the first question. Now second question, describe briefly the parts of the plaint, different parts of the plaint. Now what is a plaint? So first of all, you need not go to the details of the plaint here, or the details of the pleadings, or what should be there in the pleadings. Here they have asked you a specific question, that is different parts of a plaint. So you can directly come to the parts of the plaint. What are the parts of the plaint? First of all, the plaint should contain the following parts. Number one, cause title of the suit. You know that the first part is the cause title. Then you can give a short example of a cause title, that is a number of the case, that's original suit number, and then blank space to be filled by the court office, then the year of filing, and the suit number may be, for example, OS number 2010 by or OS suit number 568 of 2010 or 2017. Or if it is a sessions case, if it is a small cause case, or if it is a matrimonial case, according to that you can put the words, that is MC or SC, according to that, or CMIS, civil, criminal miscellaneous or civil miscellaneous. In that way, that will be the name of the suit. Secondly, forum. What is the forum? Where it has to be instituted. So first, it is two parts, the name of the court and the place of the court. So you have to write in the court of the first additional civil judge, Mysore, at Mysore, or before the first additional civil judge, that is civil judge at Mysore. So that will be the whole thing is cause title. So first of all, cause title has two parts. One is relating to the number and then the year, and secondly about the place and the court under which you are going to file. Then the second part of the plaint is the provision. So the heading will be, that is the provision under which we are filing the suit. For example, for money suits, it is Order 7, Rule 1 and 2 of the Civil Procedure Code. For other suits, it is Order 7, Rule 1 of the Civil Procedure Code, 1908. So that has to be given. Plaint under Section 26, read with Order 7, Rule 1 and 2, Code of Civil Procedure, 1908. That will be the next line. Third part. Third is the body of the plaint. So body of the plaint has three main parts. In that, facts of the case, technical paragraphs, and the prayer. So what are the facts of the case? That is, there you have to mention about the fundamental principles of pleading. They are applicable for this facts of the case. And suppose it is a suit for recovery of money, then the precise amount of the money has to be stated. The amount and the interest has to be stated. If the plaintiff has given as allowed a set off or a relinquishment of his claim, that amount which is relinquished or which is set off has to be mentioned. And where the subject matter is immovable property, the description of the property should be given in the particular plaint, sufficient to identify it. All this has to be mentioned in the facts of the case. Then technical paragraphs. After the facts of the case, there are three paragraphs which are important to be added in the plaint. First of all, cause of action. Second is jurisdiction. Third is the court fees. You have to mention that. So first you have to highlight cause of action. So date on which the cause of action arose should be indicated, which shows that the suit is within limitation. Second is jurisdiction. The basis on which this court has jurisdiction to try and decide the suit has to be mentioned. Thirdly, the court fees. valuation of suit and the provision of the Karnataka Court Fees Suit Valuation Act 1958 if it is filed in Karnataka. If it is filed in some other state, then that state's Court Fees and Valuation Act has to be mentioned, under which the computed court fee has to be mentioned. This has to be written in the technical paragraph. These are the three important technical things which has to be there in a plaint. And the last one is the prayer column. So in the prayer column, all the reliefs which the plaintiff wants to claim, which he is entitled to claim, has to be mentioned in the prayer column, because that column cannot be changed. You cannot add some reliefs later on. So the reliefs may be cumulative reliefs or they may be alternative reliefs. You have to mention that. Cumulative means all the reliefs together. I want, we can say that the court may be pleased to grant, number one, whatever you are asking. That is a specific direction to the plaintiff to do certain things or not to do certain things, to grant the order. So make an order to, and you have to write the main prayer, what you are asking the court to give you. Secondly, then you have to say other costs or interest on that money if you are asking. So whatever, cumulatively all together. Or even you can ask in alternative. You can say that if the court does not grant this relief, the court may grant this relief. You can ask for two alternate reliefs also. That comes in the prayer column. Then this is the third part, that is the body of the plaint. Fourth part is the place. Fourth part is the place, date and signature of the plaintiff. That is, immediately after the prayer, the plaintiff must sign with the place and date. And the last part is a verification clause, where he should verify that all that is contained in the above plaint are all true and correct to the best of my knowledge, information and belief. And then he has to sign with the date and the place. So these are the parts of the plaint, and which has to be given according to the answer requirement. You have to write all the parts and you have to mention it. Now the third question. Explain the provisions relating to revision and the conditions for exercising revisional jurisdiction. That is the question. So what are the provisions relating to revision? Now the same question may be asked for a short note also. If it is asked for a short note, then the answer should be short. You have to bring it down and you have to mention all the points in such a way that you are not elaborating it. But when you ask you for a long question, see, revision is discussed under section 115 of the Civil Procedure Code. So what is revision? Revision is a power of a superior court, and the superior court calls for the records of a subordinate court and examines the legality of the proceedings in the subordinate court. So the High Court may call for the record of any case which has been decided by any court subordinate to such High Court, in which no appeal lies thereto, and if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in exercise of its jurisdiction illegally or with material irregularity, then the High Court may make such order in the case as it thinks fit. So this is the provision. Revision when it does not lie. It does not lie when the court is satisfied that the order of the subordinate court is within the jurisdiction of that court, and the case is one in which the court ought to exercise its jurisdiction. Thirdly, in exercising the jurisdiction, the court has not acted illegally. If the court comes to know about these things, the court will not exercise revisional jurisdiction. That means, what are the conditions? Then you have to mention the conditions for exercising revisional jurisdiction. Conditions is, first of all, the case must have been decided, that is by the subordinate court. Second, the subordinate court, that is the court which is subordinate to that High Court where the application has been made for revision, that court should have decided the case. And third important condition is that order passed by that court should not be appealable. Then fourth condition, that subordinate court, when the High Court looks into that particular decision, it should come to know that the subordinate court has exercised a jurisdiction which is not vested in it by law, first, or it has failed to exercise jurisdiction. The court had jurisdiction, but it has failed to exercise the jurisdiction. Thirdly, it has acted in exercise of its jurisdiction illegally or with material irregularity. If one of these conditions are present, then the revision can be taken up, or the court can exercise revisional jurisdiction. Now there you have to, as it is a long answer, you have to explain. If it is a short answer, these are the contents and it could be for a short note. But when it is a long answer, you have to write again the different terms which we have discussed, you have to explain in detail. For example, we have said conditions. First is it should be a case decided. What is the meaning of a case decided? Here, case decided is not defined in the Civil Procedure Code, but the court has to interpret. That is, a judicial interpretation of the word case decided has to be done. Here, any orders which are passed in a routine manner, okay, which does not decide any substantial question between the parties, they are not case decided. They don't come within the definition of the words case decided. They don't amount to that. Now, suppose there is an interlocutory order and the case will be decided if the court adjudicates for the purpose of the suit some right or obligation of the parties in controversy. Even if it is an interlocutory order and the court decides a matter in which, in that order, it passes an order wherein those two parties' rights which are in controversy has been decided, then it means that it has decided the case on merits. That means it has decided that important matter between the two parties. It amounts to a case decided. Explanation is given to section 115, which says that any case which has been decided includes any order deciding an issue in court of the suit or in any proceeding. That means if there are issues framed and one of the issue has been decided in that particular order, it is amounting to a case decided. So you explain the word case decided. That is the first thing. Second, you explain what is subordinate court. Subordinate court means a court which is exercising judicial functions, okay, and that court should be under this particular revisional court or the high court which exercises jurisdiction. That court should be under that high court. That means it should be a court first of all. It should not be a person who is exercising judicial functions. There may be, for example, a commissioner exercises judicial functions, whether he is a court. Now, it should be a court within the meaning or definition of a court under the CPC. That has to be mentioned. Then, a court which is subordinate to the high court means the appeal from that court should lie to that high court. That means it is subordinate to the high court. Okay, that is the second point. The third point, when you say that there should be no appeal lying, then only he can go in jurisdiction. He can go in revision. We said that when there is no appeal lying against that order, then only he can go in revision. That means you have to explain no appeal lies. What is the meaning of that? No appeal lies means directly or indirectly, if any appeal lies before the high court from that order, then there cannot be revision. That means there are certain orders which are appealable orders under the Civil Procedure Code. There are some cases which are not appealable. Once the Civil Procedure Code says that once that case is decided or that matter is decided, it is final. There is no appeal to that. In such cases only, the appeal can go to the high court. So if there is a first appeal to the high court, then that means that there is a direct appeal to the high court and the high court will not take up the matter in revision. Okay, so this is the third point. No appeal should lie. Fourth is about jurisdictional error. You have to mention what is a jurisdictional error. Now, error itself, making an error. So we said that the court should act illegally or it should be a material irregularity. What is the meaning of that? That means there should be a jurisdictional error committed by that court. So, error of law itself is no ground of revision unless there is a failure or wrong exercise of jurisdiction or it amounts to a material irregularity. Here you can mention some cases which have been stated in the Civil Procedure Code. Any instances you can give where material irregularity in exercise of jurisdiction has been shown. If there is no question of jurisdiction, then the decision cannot be corrected, because there must be a question of jurisdiction here. That is a necessity for the revisional exercise of jurisdiction. Then the fifth point is discretion of the court. Revision is a discretionary remedy, and therefore it is left to the discretion of the court to exercise its power. But also, it is not necessary that revision may be exercised only on the application. Under section 115, the High Court has the power to exercise jurisdiction in revisional matters suo motu, that is on its own. It can call for the file from the court, from subordinate court, and it may decide, or it may go for the revisional jurisdiction by itself also. This has to be mentioned. So this is the complete answer which you give for this particular question. First of all, mention section 115. What are the provisions of section 115? What are the requirements of section 115? Conditions for exercising revisional jurisdiction. What is the meaning of revision? Then what are the contents? They have to be explained. Case decided, subordinate court, appeal, no appeal lies, jurisdictional error, and discretion of the court. That will be a complete answer. Coming to the next question. What is the special procedure for institution of suits by and against partnership firms constituted under the Partnership Act? If we know that Order 30 provides for special suits that are filed against partnership firms or by partnership firms. So here, any two or more persons claiming as partners and carrying on the business in India may sue, and any two or more persons liable as partners may be sued who are carrying on business in India in the name of the firm in which they are partners. They need not sue individually. They can sue in the name of the firm in which they were partners at the time when they instituted the suit, or at the time when the cause of action arose. Now here you have to mention the party should apply to the court for a statement and name and addresses of the person. It has to give the name and addresses of the persons who were at the time of the cause of action partners in that particular firm, and they should be furnished in a form verified. And where the suit is instituted by partners in the name of the firm, the plaintiff shall demand in writing by or on behalf of any defendant, forthwith declare in writing the names and places of residence of all the persons constituting the firm. That means the plaintiffs may ask the defendants to give the names of all the partners or the addresses of all the persons who are suing on behalf of the firm. So failure to comply with this demand may amount to an action for staying of the proceedings, or it may call for staying of the proceedings. Now the parties' names are declared. The suit shall proceed in the same manner as if in the normal cases which are filed under the Civil Procedure Code, and all the same consequences shall follow as if they are named as plaintiffs in the plaint. So what is the difference between partnership suits and the other suits is, first of all, those persons who are claiming as partners and those persons who are liable as partners, their names, addresses, their details at the time of cause of action accrued has to be mentioned, furnished and verified. Once the name of the parties are declared, it shall proceed in the same manner. So all proceedings shall continue in the name of the firm, but the names of the partners shall be entered in the decree. So this is mentioned in Order 30. Now when the parties are sued as partners, then to whom the summons shall be served, that has also been mentioned. It may be served upon one or more of the partners, or at the principal place at which the partnership business was carried on in India, upon any person having at the time of service the control or management of the partnership business as the court may direct. So at that time, whoever has the control and management of that partnership service or the partnership firm business, in his name the summons will be served. Now suppose the partnership has been dissolved and the plaintiff knows that the partnership has been dissolved, then the summons will be served upon every person within India whom the plaintiff wants to make liable. Because once the partnership is dissolved, the agency between the partners comes to an end and the service of notice on one party does not amount to a service of others. For example, if they are all together, they are partners, then you can serve summons to any one of the partners and it is deemed that you have served the summons to all the partners. But if there are different or if it is dissolved, then each of the partner has to be served separately or individually. Then any person who has been served with summons as a partner may enter the appearance under protest, denying that he was a partner. Suppose he wants to say that he is not a partner, he can sign under protest saying that I am not a partner and at any material time I was not a partner to that particular firm. That will be decided again. Then after the appearance is made, either in person or through somebody who appears on behalf of him, then at any time before the date fixed for hearing and the final disposal of the suit, the partner or the plaintiff may apply to the court for determining whether that person was a partner. Now when he says that he denies that he is a partner, the plaintiff may apply to the court to determine whether he is a partner or not in the firm and whether he is liable or not. Now when this application is filed to the court looks into that and decides. If the court holds that he was a partner at a material time and at that time if he was a partner he would be liable, then that shall not preclude the person from filing a defense denying his liability. Even if the court holds that, he can file a defense denying his liability in respect of the claim against the defendant. But suppose the court holds that he was not a partner of the firm and he was not liable, then the plaintiff can still serve a summons on the firm and proceed with the suit. But then that plaintiff whom the court has decided that he is not liable will be precluded from alleging the liability of that person. Plaintiff cannot allege the liability of that person because the court has decided on that matter. That has to be mentioned. Finally, where persons are sued as partners in the name of their firm, they must appear individually in their own names, as a firm cannot appear in the firm name. It is not a legal person. So the firm cannot appear in the firm's name as you can appear in the form of a company. Here, when they appear to the court, they appear in their individual names. So all subsequent proceedings shall continue in the name of the firm itself. Suppose a partner dies. On the death of the partner, whether before the suit was instituted or after the institution of the suit, Rule 4 to Order 30 says that it is not necessary to join the legal representative of the deceased as a party to the suit because the case is going on in the name of the firm. This is the answer to the partnership, that is the provisions relating to the partnership, filing the case in the name of the partnership firm. Next, discuss about arrest before judgment. Now, arrest before judgment and attachment before judgment, these are the two provisions under Order 38 which can be made when a creditor who has won a suit against his debtor, he wants to execute the decree in his favor by having the debtor's properties attached and sold, or having the debtor arrested and detained in civil prison normally. So when the case is decided, he will execute the decree by either attaching the judgment debtor's property or by putting him in civil prison so that he will pay the amount which is due under the decree. But in some cases, it is too late by the time the judgment has been arrived, and till the judgment has arrived, the person, that is the defendant, would have already sold off his assets or would have already absconded from there to avoid his arrest and detention at the time of the execution of the decree. In such cases, if the court is satisfied that the defendant is trying to avoid or delay the process, delay the execution of the decree that may be passed against him, then the court may order the arrest and detention of that person, defendant, pending the judgment in the suit. Now, at that stage, the plaintiff has not proven his claim because at that time, the case is just before the court, it is pending. The liability of the defendant has to be still decided. So here, the court has to proceed with great care and caution under Order 38. Order 38 Rule 1 you have to mention. What is Order 38 Rule 1? At any stage of the suit, if the court is satisfied by affidavit or otherwise, that the defendant, see the words, that the defendant with intent to delay the plaintiff, these words are important, you have to mention this, or to avoid any process of the court, or to obstruct or delay the execution of any decree that may be against him. So these are the intentions. Number 1, has absconded or left the local limits of jurisdiction of the court. Second, is about to abscond or leave the local limits of the jurisdiction of the court, or has disposed of or removed from the local limits of the jurisdiction of the court his property or any part of his property. In such cases, or the defendant is about to leave India under circumstances showing it probable, reasonable probability that the plaintiff may be obstructed or delayed in the execution of any decree that may be passed against the defendant in the suit. In such cases, the court may issue a warrant to arrest the defendant under Order 38, Rule 1 and bring him before the court to show cause why he should not furnish security for the same. The defendant, at the time when the officer goes to execute the warrant, if he pays the amount which is specified in the warrant, he shall not be arrested if it is sufficient to satisfy the plaintiff's claim. That is stated in Order 38, Rule 1. Now, what is the meaning of security for appearance? The defendant fails to show cause why he should not furnish security for his appearance, and the court then shall order him to deposit in the court money or other property sufficient to answer the claim. So, if he does not show cause, then the court will ask him to furnish security for his appearance, so that at any time if he does not appear, that person becomes liable. When the defendant fails to deposit in the court money or other property which is sufficient to answer the claim or furnish security for his appearance, the court may commit him to civil prison and until the decision of the suit, or where a decree is passed against the defendant until the decree is satisfied. So no person, here again there is a condition, no person shall be detained in prison for a longer period than 6 months if the amount exceeds rupees 50, amount of the value of the subject matter, nor for a longer period than 6 weeks when the amount or value of the subject matter does not exceed rupees 50. So, in which cases arrest before judgment cannot be allowed? Number 1, if it is a suit for immobile properties as specified in clauses A to D of section 16. In such cases, they are not going to arrest. To convert insecure debt into a secured debt, if that is a case, then to ensure easy execution of a decree, if you go for an application, it will not be allowed. The order is only for issuing or securing justice, not to penalize, not for convenience. If the defendant gives satisfactory reasons why he should not be ordered to furnish security, then he will not be arrested. Where the defendant furnishes security, then also he will not be arrested. Where the defendant satisfies the claim of the plaintiff, he will not be arrested. So these are the conditions when he shall not be arrested. All these things has to mention in the answer. You can also say that this order of arrest under Order 38 Rule 1 is a case decided and therefore it is revisable. It is not appealable order, it is revisable. Then there is one more section 95 which has to be mentioned in this answer, arrest on insufficient grounds. That is the next point. When in any suit in which an arrest has been effected, if the court finds that the arrest has been applied for on insufficient grounds and he has been already arrested, the court may, upon an application made by the defendant under section 95, award reasonable compensation to the defendant for the expense or injury caused to him. That is, here now the compensation limit is that it should not exceed rupees 50,000. The compensation shall be within the limits of the pecuniary jurisdiction of that particular court. Now, a suit for damages is maintainable for wrongful arrest. If there is a wrongful arrest, he can file a suit for damages. Then, any order which determines that application shall bar any suit for compensation. Once that order is passed, he cannot file a separate suit for that purpose. And if he wants to claim a larger sum by way of compensation, then he can bring a regular suit against the plaintiff and shall not take recourse to the proceedings for compensation. If he gets the compensation, he will not go for a different suit, or he can file a separate suit for a larger amount of compensation. This has to be mentioned for this particular answer. This is the fifth question. The sixth question, what are the different modes of execution of a decree? Now, the decree may be executed under different modes, which is stated in section 51 of the Civil Procedure Code. What are the modes? First, by delivery of the property specifically decreed. Second, by distraint and sale of the movable property. Third, by attachment and sale of the immovable property. Fourth, by sale of property without attachment. Fifth, by arrest and detention. Sixth, by appointing a receiver. Seventh, by such mode or manner as the nature of the relief granted may require. There you have to mention all these points. Section 51, it speaks about the different modes of execution. Each mode has to be explained. For example, delivery of property, section 51A. You have to mention what is movable property, and for specific movable property, how it will be executed. By seizure and delivery of property, by detention of judgment debtor, by attachment and sale of judgment debtor's property, by attachment of judgment debtor's property and detention of judgment debtor. Now you have to mention that property can be attached only if it is in possession of the judgment debtor and not in a possession of a third person. There you cannot go for attachment. You have to get an order from the court to that particular person who is in possession of that property, not to transfer that property to somebody else or give that property to somebody else. Then if it is immovable property, then if it is in possession of the judgment debtor, it can be executed by removing him from the property and delivering it to the decree holder. So this is called as actual possession. If it is in the possession of some other person having right to possess the property, for example, in the hands of a tenant, then the execution can be done by affixing a warrant on that conspicuous part of the property and proclaiming the substance of the decree to the occupant by beat of drums or other customary mode. This is first one. Second is sale of property, section 51B. There you have to mention property within the local limits of the jurisdiction of the court, territorial jurisdiction of court, belonging to the judgment debtor may be attached and sold, or even without attaching also it can be sold. Sale without attachment can also be done. It is not a nullity, it is an irregularity. Then once the property is attached, notice is issued to the judgment debtor so that he shall not transfer or create encumbrance over the property. Now look at this. Now when we speak about the different modes of the execution, here you need to just give the details of each mode. In short, that is sale of property, what are the provisions? Arrest and detention 51C, what are the grounds for arrest and detention? There are 4 grounds, you have to mention those grounds, that's all. That is the judgment debtor with an intention to obstruct or delay the execution is likely to abscond, or after the institution of the suit, he has dishonestly transferred or removed some property or any part of it, or the judgment debtor has means to pay the amount but he has refused or neglected to pay the same. That you have to mention. So these are the grounds. That's enough. Then the fourth point is appointment of receiver, section 51D. Here, instead of selling the property or which is attached, the appointment of receiver is made for that particular property. This is called as equitable execution. It can be done by the court. It is at the discretion of the court to appoint a receiver for that property which is attached, and the receiver will take care of the property and see that it will be kept intact for the purpose of execution of the decree. Then if there is no other mode of execution available, then this mode can be made use of. This is beneficial both to the decree holder and the judgment debtor. Then fifth, partition. In case of partition of an undivided estate assessed to the payment of revenue of government, or for separate possession of a share, then the partition of the estate or separation of the share shall be made by the collector or any gazetted officer deputed by the collector, because the object is that the collector is more equipped to execute the particular decree in the different modes. So it has to, in accordance to the law, the collector will take action and he will attach the property according to the procedure. So these are all the methods of execution, mode of execution. You need to just mention the methods and you need to explain in short. But suppose there is a question totally on one method. For example, delivery of property or sale of property or arrest and detention. Just say that explain the provisions relating to arrest and detention. In that case, the details have to be discussed, the conditions which we have stated just now, they have to be elaborated, and you have to give the meaning of those terms which are the keywords. It will be a longer answer. If one particular property or one particular question is asked on one provision. For example, if they ask a question relating to attachment and sale of movable property or immovable property, then the total discussion on movable property and immovable property has to be done, along with, if you have cases, you can mention the cases. Now, there is one unit about the Limitation Act, where before the expiration of the prescribed period of the limitation, acknowledgement of debt. What is the meaning of acknowledgement of debt under the Limitation Act? Now, when there is a period of limitation for every debt, after that you cannot secure the debt under the Limitation Act. But before the expiration of that period, if that party has made in writing an acknowledgement about that claim or that property, then by any person through whom he derives his title or liability, or he himself, then a fresh period of limitation can be computed from the time when the acknowledgement has been signed. So what are the conditions for valid acknowledgement has to be stated. That is, the acknowledgement is of an admission of the fact which is true. Such acknowledgement must be in respect of a liability, in respect of property or right. It must be made before the expiry of the period of limitation. It should be in writing and signed by the party against whom such property is claimed or an agent duly authorized in this behalf. When the writing is undated, that is, which is containing the acknowledgement, if it is undated, then oral evidence may be given when it was signed, but subject to the provisions of the Indian Evidence Act, it will be admitted. Then there is an explanation to section 18, which says that an acknowledgement may be sufficient though it omits to specify the exact nature of the property or right, or avers that or states that the time for payment, delivery, performance or enjoyment has not yet come. Suppose it is stated in that manner, or is accompanied by refusal to pay, deliver, perform or permit to enjoy, or is coupled with a claim to set off, or is addressed to a person other than a person entitled to a property or right. These are the conditions. That is an explanation which says that an acknowledgement is sufficient acknowledgement if these things are there. What is the meaning of signed? Signed means he can personally sign or through an agent who is authorized by him. Then an application for the execution of a decree or order shall not be deemed to be an application in respect of any property or right. The acknowledgement must be unconditional. It must be an acknowledgement of existing liability. It is not only a promise to pay, and even a person may deny his liability, but still he may promise to pay. Because even if I do not have the liability, I may say, okay, I'll pay. That doesn't mean that it is an acknowledgement. Acknowledgement means he should first say that, yes, I admit the debt, and then he should acknowledge. These points have to be stated in this answer. This is relating to the long answers in this particular paper. Let us listen to certain things. Let us consider certain things, that is, which we can answer in the form of short notes. Now write short notes on these things. First, set off. Set off. Now set off. Secondly, substantial and procedural laws. Third is adverse possession. These are the three short notes. First of all, set off. Now, what is a set off? It is a reciprocal acquittal of debts. That means when there is an action to recover money, set off is a cross claim for money. Now, by the defendant. The defendant may at the first hearing of the suit, but not afterwards, unless permitted by the court, present a written statement containing the particulars of the debt sought to be set off. What is the effect of set off? The written statement shall have the same effect as a plaint in a cross suit, so to enable the court to pronounce a final judgment in the original claim and the set off. Types of set off. There are two types of set off: legal set off, equitable set off. You have to mention both of these have to be distinguished. What is the difference between legal set off and equitable set off? Of course, equitable set off is a concept which has come from the English law. That is, Rule 6 is a legal set off. Again, if it is not in Rule 6, Still there is a set-off. It is an equitable set-off. Legal set-off has these following conditions. It must be for the recovery of money, and it should be for an ascertained sum of money. It should be legally recoverable. It must be recoverable from the plaintiff, and the amount claimed by way of set-off should not exceed the pecuniary limits of that particular court. That is, pecuniary limits of the jurisdiction of the court. And both the parties must fill in the same character as they fill in the plaintiff's suit. These are the legal set-off. Equitable set-off is that form of set-off in which Court of Equity in England allowed when cross demands arise out of the same transaction. The main distinction is that equitable right of set-off means it should arise out of the same transaction. That is, the claim of the plaintiff and defendant should arise out of the same transaction, which is not there in legal set-off. Secondly, though cross claims, though not arising out of the same transaction, it is that where the claims are connected to each other, and even if it is not for a ascertained sum of money also, you can go for a equitable set-off. So it is not sufficient that there are cross demands. In equitable set-off, there should be a connection between them, and it should be inequitable that the defendant should not file a different or a separate suit for that purpose. Not required to file a separate suit. That has to be mentioned. So you have to first mention what is legal set-off, what is equitable set-off, the conditions of both, then the distinction between the both. That is the answer. Second, substantive and procedural law. You have to mention what is substantive law, what is procedural law. Substantive law are those laws which specify the rights of the parties under the law. Okay, and procedural law are those laws which are required to bring an action before the court. That is, you have a right, but that right has to be exercised by filing a case before the court, and what is the procedure to be followed before the court is stated in a procedural law. Civil Procedure Code, even though there are some procedural laws like Civil Procedure Code and Criminal Procedure Code, in the same procedural laws there are substantive provisions also. So the first part of the Civil Procedure Code is a substantive part where we have the sections, and the second part is the procedural part which speaks about the orders. So that is the actual procedure before the court. They are interdependent. So without a substantive law, there cannot be a procedural law. Without a procedural law, there cannot be a substantive law. If you want to have a right, you have a right in law, that is ubi jus ibi remedium. You have a right, there is a remedy. Then what is the remedy? That remedy is a procedural law. So the importance of the substantive law depends upon the quality of the procedural laws. How effective is the procedure? You can so effectively you can see that your substantive rights are exercised. So under the substantive law, a person can approach the court for redressal of his injury and for compensation or for the rights which he has under the law. Procedural law allows the court to redress the grievances in a just and fair manner. Now, suppose there is a decision of the court on a substantive law that is called as a case on merits, deciding the case on merits. If a decision of a court based on a procedural law is made, then it is not on merits, but it is on the ground of technicalities. So sometimes the procedure also can be brushed away or can be taken leniently. It may not be strictly observed if the substantive rights have to be enforced. So what is the difference between the two basically is substantive law determines the conduct and relation of the parties inter se, while procedural law regulates the conduct and relation of courts and the litigants inter se. Then substantive law deals with the ends which the administration of justice has in its mind. Procedural law deals with the means and instruments by which the ends of justice are achieved. The question as to what facts constitute a wrong is a substantive law that is determined by a substantive law. The question as to what facts constitute proof of that particular right or that wrong is a question of procedure. Substantive law defines the rights. Procedural law defines the modes and conditions of the applying of those rights. Substantive law deals with the matter outside the courts. Procedural law deals with the affairs inside the courts. So this is the difference between substantive and procedural law. Third, adverse possession. Section 27 of the Limitation Act speaks about adverse possession. That is, if a person is in possession for a particular period, then he perfects his right to that property to which he has the possession. This is an exception to the general principle of law of limitation. That is, once a person is in possession for a particular period, the person who is having a right in that property, his right is extinguished. This section 27 does not apply to a person who is still in possession of the property. It is applicable to only those who are out of possession or are seeking to recover possession. Where there is no period of limitation provided, it does not apply. Only it applies where there is a period of limitation provided. It does not apply to applications, it applies only to suits. It is not merely procedural, it is substantive in nature, though it is in the Limitation Act. It extinguishes the title of the rightful owner. Section 27 extinguishes the right of the rightful owner, title of the rightful owner, and the rightful owner does not institute any suit for recovery of the possession within that period which is prescribed. He loses the right over the said property. So it applies both to movable and immovable property, and it has to be within the period of limitation, it has to be exercised. Now, what is the effect of section 27, that is of the Limitation Act, is that right to property shall be extinguished after expiry of a period limited for instituting a suit for possession of the property. Suppose the plaintiff fails to bring the suit for possession based on his title within 12 years of dispossession, then any suit brought before expiry of 12 years, here the adverse possession will not be perfected. But if he fails to perfect his title or ask for the remedy before the court within 12 years, then he extinguishes, his complete title is extinguished. But if he exercises his right before 12 years, then even though that period is extended after 12 years also, his right is there. His rights will not be extinguished. So a person who is claiming adverse possession has to prove that he has remained in uninterrupted possession of that particular property to the knowledge of the true owner, and he has denied the title of the true owner and asserted his own rights of ownership in the property to the exclusion of the true owner. Mere possession for any number of years cannot constitute adverse possession. Adverse possession means that that person has a knowledge. This person in adverse possession is staying in that, or he is possessing that property to the exclusion of the true owner, and he has asserted his own rights of ownership. Once the property's title, that is the title of the rightful person, has been extinguished by adverse possession, his re-entry to the property will not revive the lost title. Once he loses his title, he will not get it back. So this is a provision which provides that a person should be vigilant if he has a property. He should not allow himself to be dispossessed beyond the period of limitation. This should be the answer to your question. Okay, so this is the paper which we have discussed just now. Now let us look into some